So this is the second video after you've watched the first video on freedom of religion about the idea that we have freedom from religion and freedom of religion in this country. So as I discussed in the last video, the freedom from religion is considered the Establishment Clause, where no state or federal government can establish a religion, and the Free Exercise Clause, which is where you can exercise your religion freely, is called the idea of freedom of religion. So what this set of videos is going to talk about is the Free Exercise Clause, which is your freedom of religion. And in the last third series of videos, we'll talk about freedom from religion. Now, something particular to know about these cases, the Free Exercise Clause cases, is that usually what we've been saying is whether a law is constitutional or unconstitutional, right? This whole time, we're seeing if the Supreme Court says the law is constitutional, so it gets to stay, or the law is unconstitutional, so it goes away, okay? So for example, if the law was constitutional to say that motels had to let Black people stay there, then the law stays. Or if the law was unconstitutional to have no child labor, the law goes away and you can have child labor, okay? So that's typically how it goes in most constitutional cases that we're learning about. Now with the Free Exercise Clause, your freedom of religion, it's a little bit different. Here what you're doing is you're asking for a religious exemption usually. And what that means is that other people will still have to follow the law still stays, but you don't have to follow it because of your religion. We'll talk about it later, and I'll link videos for independent research, but religious exemption is used a lot right now. There's been a lot of recent cases, mostly with different religious companies saying that they don't want to provide birth control to the people that work for them because they don't believe in birth control. So the federal law that says insurance plans have to include birth control in your insurance plan, they say that law can still stay, but they shouldn't have to follow it because it violates their religion. They want a religious exemption. So as we go through these cases, understand that for the most part, people aren't saying declare this law unconstitutional. What they're saying is that this law is constitutional, but I shouldn't have to follow it because of my religion. So a foundational case for this is Sherbert versus Verner, which was decided in 1963. And this was a case about a Seventh-day Adventist who worked at a commercial store, and the store was requiring her to work on Saturday, but Saturday is the Sabbath day for Seventh-day Adventists, like Jewish people, instead of Sunday. And the store was closed on Sundays. But they were requiring her to work on a Saturday, and when she wouldn't, they fired her, and she tried to get unemployment, but she was denied unemployment by the state because they said that, basically she wasn't willing to work days she should have worked, and it's her fault she was fired. And unless she was willing to work on Saturdays, she can't get unemployment. So she sued, saying that she should have an exemption to this law. The unemployment law that says typically you have to be able to work in order to get unemployment can stay, but for people like her, whose Saturday is a Sabbath, they shouldn't have to work on Saturdays. And the Supreme Court agreed with her, okay? The Supreme Court said under the Free Exercise Clauses of the under the Free Exercise Clause of the First Amendment, Seventh-day Adventists should get a religious exemption and should be able to get unemployment even if they won't work on Saturdays. Another case is Wisconsin versus Yoder, and Wisconsin versus Yoder was decided in 1972, and this is the case that's the basis of homeschooling in this country today. And what this was is there was a law in Wisconsin that students had to go to a public school until they were 16 years old, and Amish people wanted to take their kids out after 8th grade when they were 14 years old. So they sued saying, this law is fine, you can require education until people are 16, but Amish people shouldn't have to send their kids after 8th grade. And the Supreme Court agreed. The Supreme Court said you can get a religious exemption. The Amish parents in the case had argued that it would corrupt students, it would expose them to all sorts of things against the Amish faith, and that it was important they stopped education at 14, and the court agreed that you can't mandate that people go to school that much longer, and that parents can educate their children as they choose. And if Amish parents want to educate their children through farming and through craft and technique and trade, they can do that. So those are the types of examples of religious exemptions in these really big famous cases. Another case is employment division versus Smith. And what happened in employment division versus Smith is that it was a 1990 case. And for the most part, we used to allow religious exemptions very freely. You could see Amish people got the exemption, Seventh-day Adventists got the exemption, but this changed in 1990. And what this was about employees who were indigenous, and they said that using peyote as part of their church rituals was part of their religion, and they used peyote in church, in very controlled religious ways, and they were fired and denied unemployment because they were fired for using drugs. And the Supreme Court said, okay, the law that you can't get unemployment if you use drugs is fine, but we should have an exemption because our religion requires us to do this. And other things that, they would never use drugs while at work, and that the use of peyote in churches was done openly and freely in this state. And everyone knew that the church was using peyote, but didn't have any problems with it. And the Supreme Court said no. The Supreme Court said you can't have this exemption anymore. And they said because this law wasn't meant to discriminate against you, it was meant to just stop people from using drugs, we're not going to give you an exemption. And that was a really big change because the Amish people got an exemption, even though the law saying you had to go to school till you're 16 wasn't made to target Amish people. And the law that said you had to be able to work all days to get unemployment wasn't meant to discriminate against Seventh-day Adventists, but so it was a very big change. A lot of people were really unhappy about this case, and Congress passed a law trying to say we should give people exemptions more often, which is the Religious Freedom Restoration Act of 1993. It was a bipartisan bill after this employment division versus Smith case saying, hey, hold on, we have a big tradition in this country of giving religious exemptions. We should really keep giving religious exemptions. But in a subsequent case, City of Boerne versus Flores in 1997, the Supreme Court said no. The Supreme Court said, we already decided you can't have religious exemptions as freely anymore, and Congress can't change it, only we can. So where we are now is that it's much harder to get a religious exemption, but the new current cases sort of point us in other directions. So I'm going to send you some links and videos for that. And that's it for this video on the free exercise clause.